Evening, ladies and gentlemen. Welcome to our January 9th, 2019, first meeting of the year meeting. Happy New Year to everyone. Madam Secretary, would you please take the roll call?
Chairman Curry.
Here.
Mr. Prince.
Here.
Mr. Goldenberg.
Present.
Mr. Vino.
Here.
Mr. McNamara.
Here.
And Ms. Gannon.
Here.
Thank you. First on our agenda, we have two sets of minutes to approve. The first one is from our November 14th Planning Board meeting. Any changes, comments? If not, I'll make a motion. We accept the minutes as presented to us from November 14th, 2018.
I'll second it.
All in favor?
Aye.
Thank you. And the second set is from that special meeting that we had.
The short meeting.
Yeah, the very short meeting. But I think it's set a record for the Odell property, and that was on November 29th, 2018. Any changes or additions to that? Make a motion, we accept the minutes as presented from November 29th, 2018.
Second.
All in favor?
Aye.
Thank you. First on our list is a couple of time extensions. The first one is for the McKenna final subdivision approval. We're in receipt of two letters, one from our town planner and one from Insight Engineering. This is a request for a second 90-day time extension of the final subdivision approval.
I'll second it.
Okay, the approval, what would be is for subdivision approval, stormwater management, and erosion and sediment control permit, steep slopes and tree preservation. And the dates are from December 10th, 2018, up to and including March 9th, 2019, pursuant to Town Law, Section 276C, and Town Code, Section 50-13M. For the record, the property is located at 2652 New York State Route 35, and it's in an R80 zoning district. Do we have a second?
Second.
All in favor?
Aye.
The second is request for the sixth 90-day time extension for Granite Point. We're also in receipt of two letters, one from our town planner and one from Bibbo Associates. You want to comment, or I don't think if anybody has any questions? This is, I'm sorry?
Planner had no objection.
No objections, no actual recommendations. So this is a subdivision regrant, final subdivision approval, wetland steep slopes, tree preservation, stormwater management, and erosion and sediment control permits as per resolution 2017-10, and the dates are from February 2nd, 2019, up to and including May 2nd, 2019, pursuant to Town Law Section 276-7C and Town Code Section 50-13M. This property is located at the east side of Route 118-202. All right. Next is project review of North County Homes. Oh, didn't we?
No.
Did I not? I'm sorry.
No, it's okay.
We have a couple of seconds, so now you want to vote too? Jeez. All in
Steve.
favor? Aye. Thank you. Good catch. Worth it for you to come. Yeah, I know. Let's hope not. We're in receipt of two letters also here from our town planner and from Woodard and Curran. Whichever one you wanted to go through it first, or
On North County Home?
and North County Homes, yeah.
Is the applicant?
He's here. Do you want to give a brief presentation or anything?
Well, Jack's not able to come tonight.
Okay.
It's just, if any questions, I'll do my best.
Okay.
Essentially, at the last meeting, we jumped the gun a little bit because the board had suggested that we prepare a resolution, but there were several actions that we still had not yet taken. So the board needs to take those actions tonight on preliminary subdivision. One, I can go one by one, but the first thing that needs to happen is you need to accept your role as lead agency under SEQRA. So if you would make a motion and then vote on that.
We didn't do that last time?
No, we did not.
No, we didn't.
I thought we did. Oh, okay.
No, we didn't.
We discussed it, but
I'll
we...
make that motion.
I'll second.
All in favor? That's to accept our role as lead agency under SEQA. Okay?
Aye.
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 Okay, and then I prepared the Part 2 EAF and the negative declaration. If you've had an opportunity to look at those, the negative declaration really only focuses on some minor issues that were addressed, and there is no significant adverse impact as a result of those, which is the impact on land, the impact on groundwater, and impact on human health. So, are there any questions related to those issues in the negative declaration?
In the EAF?
Well, the
Yeah,
EAF, and those are the items that might have had a small to moderate impact.
Okay.
So they have to be identified in the neg deck. Impact on land is the steep slopes, and those were modified in the driveways. The impact on groundwater, in terms of the town Amawak-Shenorock Water District, includes the construction of permanent stormwater management structures, et cetera, and limited impervious coverage. And on human health, DEC had identified the nearby Granite Point site, and that is obviously the DEC portion is being cleaned up, the other one is under conditions. So they are not related directly to this site, they are being taken care of separately.
Okay.
So those were the three items, so there's no significant negative impact on the environment as a result of this. So if the board agrees, you should vote on the negative declaration.
That's interesting, because they're really not cleaning it up. You know, that's just an aside on my part, you don't have to include that.
Well, I mean, it only shows up on the DEC mapper, so you have to address it.
Yeah.
Right.
So,
Any other comments? Otherwise, I'll make a motion to approve the neg deck.
Second it.
Okay, all in favor?
Aye.
Aye.
Thank you. Wanna look at the preliminary resolution.
Yeah, Joe's memo dated today was,
Yeah, so
Yeah.
let me just go through, I mean, the applicant's done a nice job, I think, addressing our comments. I just want to inform the board, if you remember last time we were talking about putting some stormwater infrastructure, even though they were below 1 acre of disturbance, we asked them to take a look at what they could do. They've done that. They've proposed, stormwater mitigation that, again, is over and above, it's not required. So one of the open items is just to give me some testing, signed and sealed testing results on that. So that's a relatively minor item, but the board should feel good about what this applicant has done relative to stormwater. They've added the note about the construction fence that I was concerned about getting over 1 acre, so that's on there.
Yes.
And we got, the other two remaining comments have to do with really survey. They're gonna get us a final survey, and they're gonna show the trees on it. I mean, that's basically the outstanding items, and getting providing the DEP sign off, and, some lighting stuff. I mean,
normal course of business.
there's nothing on there, unless the board wanted to see the lighting before going to resolution. That would be the only item that the board might normally look at, but everything else, I think, would be typical to have as conditions of approval.
Okay.
Okay?
so we're looking for approval of the preliminary subdivision,
On the resolution,
of the resolution,
yeah.
and if you have any comments on the resolution.
1901,
Page 2.
1901,
Right.
first of the year,
It's the first, 1901.
Yeah, 2000,
Yeah.
it's the 01, the
first of
first
the
one.
year.
First
Page
one.
2,
I'll move it.
this is a fly spec kind of a comment, but under the second to last whereas, planning board declared its intent to be lead agency, not leaf.
Where are we?
Page 2, second to last whereas, we've got leaf instead of lead.
Oh, yes.
Like I said, fly
Ah.
spec,
Typo.
Well, we're all for leaves, but
Leave.
but, exactly.
On page 1,
page one, yeah.
yeah, I found a typo, and as a result of finding the typo, I discovered something else. At the bottom where proof of taxes paid, I'm sure you paid your taxes.
Oh.
So this has nothing to do with whether you did or you didn't. It has to do with what we have to do. It says,
2018, I
proof
see.
of taxes paid, letter dated June 29th. I think you really want a letter from September at least. Because this means his taxes were paid through June. this document is dated January 9th.
Except, this is talking about the original application, Nancy. These are the documents that we received at the time.
That may be so,
You
but
can add it as a condition for prior
Yeah,
to
they-
final approval, they should provide an updated
it
statement.
should have the update because the code reads, you can't appear before us if your taxes aren't paid up. And I therefore think that this document it looks silly because it says January 9th and he's only paid his taxes through June. I mean, that's what this document says. I'm a literal person.
2018, it says
Yeah,
two.
I just changed that, but.
I say it with humor. It's
So we
just,
can make a condition 14,
Wouldn't that just
applicant
be part
shall.
of the final?
Excuse me?
Wouldn't that be a condition in the
Yeah,
final?
Sure,
Well,
so then we'll
yes.
make it a condition of the final.
Right.
But this has to remain like this.
why?
Because that's at
Because
the time of
it's at
application.
the time of application, these are the documents we received. That's
Those are
all
the
that
ones.
this is
It's like a
saying.
catalog of what was received.
What was
At the
received.
time.
No more, no
Okay.
less, a
All right.
catalog. Think of it that way.
But you understand, I know your taxes are paid.
Any other comments on the resolution?
I'll move it as amended.
Yeah.
Is there a second?
Second,
All in favor?
Aye.
Aye.
All right.
And for the record, it's Resolution 2019-01.
Yeah. And now, prepare the final and give us a new tax bill.
Yeah, right.
Thank you.
thank you, Sir Bob.
Thank you for your cooperation.
John, I just have a question. We're approving the division of the two lots.
Correct.
And
No,
in here is the frontage on one of the lots is only 50 feet.
no, it's not even a code.
And that comes under this division that we're allowed to do 1/5.
Right.
Let's change it.
Pardon my ignorance, but it says here it's okay as long as the permanent, as the full minimum width requirement is met at the front yard setback. Where is that? Where is that on this?
Why don't you, Joe, Bruce has a question for you. If you know, I mean, I would just approve it, but you might as well just answer his question if you don't mind.
Whether
Yeah,
you think
Joe.
there's any things that you-
I have, excuse my ignorance on this, but on lot one, where they have a lot frontage of 50.79,
Which one are we talking about?
North County Homes.
North County Homes.
I don't have it in front of me, yeah.
I assume they're applying for this, whatever we call it, approving new subdivision. They can reduce the frontage to 1/3 of the required 150 feet for the frontage on lot one. Yeah, you gotta turn it around.
I think that the frontage, if I recall, when the code changes when you're in a cul-de-sac, so the-
Right, no,
And
it
the
does.
cul-de-sac-
That's when there's
They
a,
just have to meet it at the front of the building.
oh, that's what I'm saying. Minimum, it has to be met at the front yard setback.
Yeah,
Where
I
is- where is-
reviewed all of this in my earlier memos.
Yeah,
I can
sorry.
fish around for them, but I know that I reviewed it, and if he did not meet them at the time, I noted it, and he had to make those revisions.
Yeah, no, I just for my own information, what determines the front yard setback? That's what I'm confused about.
It's code.
It's in the code.
Right,
Oh,
so
okay.
there's this is probably a 25-foot front yard setback, right? So you would come off the property line back 20 feet and measure it at that.
Is it R10?
It's not exactly what
No.
it is. It has to do with.
R40.
R40 is 40 foot.
It has to do with, there's in different zones, or 40, blah, blah, 10, 40, whatever. There are different, I can talk to you.
No,
about
that's
that.
all right, okay.
But there are different requirements for different things as to what it is. I know it was reviewed, I know they would need it, and we can,
Okay, that's
Give you the
fine, I
details on it, Bruce.
wanted to explain.
Right, so in other words, what it is actually is you can't build anything inside of it. What you're building, you have to have your house a certain far distance back.
Right,
That represents the setback.
Okay.
And that's defined differently by zone,
Each zone,
Yeah.
in each zone.
R10 is 25, R40 is 40.
Yeah, no,
Right. I've been living in R10 land,
Yes.
working on sewers.
Okay, next on our agenda is applications for two special permit renewals for wireless facilities. One is located at, we'll do the first one at 121 Route 100. It's the property owned by the Amatos. Good evening.
Yes, hi, good evening. My name is Michael Sheridan. I'm an attorney with Snyder and Snyder, the attorneys for New York SMSA Limited Partnership, DBA Verizon Wireless. In connection with this first application and in connection with the second application, I'll combine them briefly for a few moments.
Okay.
We received a memo from the town's planner. We have put together a response to that memo, which includes the requested information, which I have here, and I have enough copies for everybody, so I'd like to hand those out for both, and we can discuss them briefly if you have any questions.
While he's doing that, Bruce, in my memo of, just found it, just switched memo to the planning board. There's a footnote in the zoning. My memo of November 1st. I
Okay,
addressed it.
okay, thank you.
You have that memo, it's in there. What are we getting from you, Michael?
Read the certification we got from
It's
this.
not mine, it's yours.
Read that first one. Yeah. No, this is from their structural engineer.
On the first,
First and second.
Here,
Yeah.
looks similar to the same that was a part of the structural analysis that somebody else signed off on. It's another, I want no liability.
Thank you.
Take the paper, take the paper, take the paper.
16 pages.
Which one are we doing?
3 pages, the other one's 16
Do it
pages.
at the next meeting, if they haven't,
Amato.
do something.
Amato, we're doing Amato
Amato
first,
first?
yes. Yes,
We're doing
Amato.
first.
yes.
Where's
The
Mr.
ugly one.
Gordios?
Oh, they're all of it.
What a
In
difference a
connection
year
with
makes.
the town planner's memo, most of the requirements were submitted and in compliance. The few that were outstanding for the first application that we're on, for 121 Route 100, requested the underlying structural report, which we have provided, which is why the first response is so thick.
Right,
The additional information was regarding co-location requested. As Verizon Wireless is not the owner of the tower, they are not the entity that would be getting co-location requests for processing or doing anything with co-location requests. However, we did reach out to the tower owner, who indicated that Sprint, they've recently come to an agreement with Sprint. I don't know if it's come before this board yet, but they have as an additional co-locator, and according to the tower owner, there are no other co-location requests at this time.
Saret, do you want to run down the questions that you provided for
yeah.
us to be answered to?
I do, and I want to make sure that Joe is in agreement with everything, so, Joe,
I'm just looking at the structural language on this, so.
can we get to that? 'Cause
Oh,
one-
I thought you wanted, you. I
No,
thought you
no,
were
no, I'm
queuing
going
up.
one by one,
Okay.
when we get to that one. First, I will tell you that your payment, will be due a refund for your client, because relooking at the town board resolution, which was done in December, for a renewal application, what they approved was not $1,000, it was $500. So your client will be getting a refund. I wanted to state that publicly.
Good to know.
Okay.
Ah, that's a-
That's a
Sure you
first.
want to get me involved in that project?
Yeah.
Okay. Users of the facility, is that what you were referring to, that Sprint is going to be, or?
That's my understanding, is that as far as co-location, the tower owner indicated that Sprint is going to be a new co-locator on that tower. and that there are no other co-location applications at this time.
Can you speak a little louder, please?
Sure, sorry.
All right, the code, these are all things that are required in the code. It's not me just thinking them out. The code is very specific about what an applicant has to provide for a renewal. And so the next one is description of all equipment at the facility, and based on what's there now, you did provide that.
Yeah.
The third one is the one I think Joe may want to give an opinion on, but what is required is a report from an engineer specializing in structural engineering, certifying the facility is structurally safe. They did provide a letter, I think Joe has some questions about this, on December 3rd, but it referred back to another study. What was not provided was a copy of that study, and we requested that that report be provided because the engineer was not really giving an opinion, he was only referring back to the earlier report, and we did not have a copy of that report. Now, Joe may want to say more about that. Yeah.
So, when I look at this, what we have here is somebody, I suspect Bennett and Pless is not proximate to the site, so they didn't do the site inspection, but they did the analysis, right?
Well, Bennett & Pless is the tower. Again, this is not Verizon Wireless's tower. Verizon Wireless is merely a co-locator on this tower.
Right.
So they're not the ones who are, have access to climbing the tower. They don't have access to all the information for all the other co-locators on the tower. They're merely a tenant on this tower.
Mm-hmm.
So what we did was when that request came in, or as your code requires it, we went to Verizon's engineer, said we need to get a letter certification that everything is, there's no issues at this tower. They said, can you please get the most recent structural from the tower owner, which is what we did for both. They were able to review those. They went out and did the site inspection, which is required by our code, and they were able to, based on the signed and sealed reports that they had, they were able to sign and seal their own letters saying that there wasn't any issues at the tower.
Right.
But again, some of these requirements are really more for the tower owners, in my opinion, and not for co-locators on the tower who really don't have the access or the ability to be able to
Right,
do
so,
this.
so not to debate that point, because I would let Joe debate that with you, but relative to the language of the letter, so here's the thing that, I haven't spent a lot of time on this, right, but what I see as a flag is, a little bit is, the person you sent out there basically says, yep, it looks like the stuff that's on here is what was evaluated in the report, right? But it speaks nothing towards the condition of the pole and the foundation. I assume that he or she, in doing their inspection, looked at the structural elements and report them to be in good condition, but I don't think the letter states that. What the letter states, as quoted here in yours, is they said their inspection appeared to match the antenna loading used in the most recent structural analysis. So it's really just focused on the loading and not on the condition of the pole. And I think there needs to be an element that's focused on the condition of the pole.
I think
Which one are you-
the report. The handout has the
Right, but the
718.
report is the structural analysis.
Bennett and Please.
Well, which letter are you looking at?
I'm looking at, I think the right one, January 9th, 2019, your comment response letter, right?
Right, but if you look at, the comment was just requesting the underlying report. But if you look at the structural consulting services letter from December 3rd, they said at the time of our visit, the existing monopole and foundation appeared to be in good condition with no visibly apparent signs of defects, damage, or structural
Okay,
deterioration.
I hadn't seen that. I was just reading off of this. I'm comfortable with that language.
Okay.
This just appeared, you only referenced the loading piece in this comment. And maybe that was because that's what Surratt had in her comment.
I think based on this letter, she requested additional information, and it was the additional information that I was
Okay, so
supplying.
the only thing that I'm gonna just need to check is just check up on Bennett and Plus. I've never seen them. I'm sure they're registered to do work in New York State, but I just have to check that.
Again, this is the tower owner.
Right.
Structural firm. I'm assuming they are as well.
They have a New York PE, but that doesn't necessarily mean that the firm is licensed to practice in New
I would
York. so-
hope they would be, but
Because when I see Atlanta, Boca Raton, Charlotte, and Chattanooga, we just have to check that. But other than that, as long as they looked at the condition, which the December 3rd letter sounds like it does, I'm comfortable
Joe?
that this structural analysis report covers it.
Can I ask a newbie question?
Yeah.
Why isn't the tower owner asking for this? Why is one of the people in the tower asking for this renewal permit?
Well, I actually was thinking about that as I went through this. Usually the special permit is issued to the tower owner, isn't it?
This is where these get
We had that already.
somewhat confused. There are special permits issued, as best I can understand from the history of what has happened here. There are special permits that have been issued to towers, and often at the time the towers come in, they come in with probably some co-locator. Michael, tell me if I'm wrong on this, but at least this is what it appears I have observed from the past approvals. And then over time, other co-locators come to that particular tower. So there are permits for the tower, and there are permits for the individual co-locators. And presumably, they all need renewals in 5-year periods. This has not happened regularly. And we'll get to that in a minute on this, but one of the things several years ago, I think on the first couple of ones that I did with this board, I asked for some input from the town attorney, and what we determined was the following. Any of the approvals for special permits that came into this town prior to 2002, which was the date of the incorporation of the telecommunications 170-129 section of the zoning ordinance, any of those, when they need a approval for either new locators or renewals, et cetera, they go back to the zoning board, because the zoning board was the originator of their approvals. Anything post-2002, when that ordinance was in place, comes back to the planning board. We have developed in my office a list of all of the towers, and we know which ones are pre- and post-2002. So when I get calls, first thing I do, look at that list and either tell them they're with me or they're over at the zoning board. So that's how they are here. They came in after 2002. So that's the first thing you need to know. The second thing you need to know is it appears to me that they should have asked for a renewal a year ago,
Right.
because their 5 years was up a year ago from their original approval. They're here now. We did this one other time with Cuddy and Fader when they were representing another of their clients, where, if you recall, they were in between, and we gave an approval for one part of it for 2 years, and then they had to come back, and it was 3 years, et cetera, because they were late.
Right.
So Michael is here now, representing his client, except for the report that we're waiting for. He's now giving us the other information. As long as Joe is satisfied with that, when they come back for the next meeting, I would say that they have complied, pending Joe's approval, and we can prepare a resolution of approval. But the question that I would say the board has to deal with is whether that approval should be for 4 years or 5 years. I'm recommending 4 years,
To bring it into sync with the normal 5-year period.
because we're already 1 year
Into
into
the
what that
5
5-year
years.
period should be.
I have a question now. Are there any distinctions, and I should have read it, are there any distinctions between the permit that's issued to the owner of the tower, as in a structural permit, versus a permit that's issued to a user of the tower, like one of the various
Like
cell, like Verizon or AT&T. I view those as two different permits. One's a structural permit and one's a use permit. And maybe the code ought to say it a little more clearly.
Well, I know-
Let me just mention one thing. At the moment, the only thing, thank goodness, that our office has been getting has not been for new poles. It's been for additional users on existing poles
What about
and
the-
upgrades. Like, something must be going on up there because we've been getting a lot of calls.
I understand new users or upgrades, but what about the permit renewal requirement for the pole itself? That's it.
I haven't had to deal with that since I've been here yet.
We haven't had a 5-year?
We haven't had a new pole.
No.
But we've done special permits on, we just did one in.
Did they pay for the old pole?
Yeah, we've done special permits
For existing
for,
poles.
for existing pole renewal.
That's a
Have we
structural
done it for
permit
this pole?
versus a use permit. That's
Yeah,
all I'm
there's-
trying to get.
there-
I'm trying to get the two of them.
This was approved
I will
5 years ago.
use a term that I am not the most, I'm not an expert in this, far from it. But as I recall, we had detailed reports for some of those related to the emissions on radio heads and how they do or don't meet the federal standards, et cetera. So that's something that we're not dealing with on this application. It's just a renewal. So,
Use permit.
Yeah, but I have a more basic question, and maybe I'm wrong, but he's a year late coming in for his renewal, for the permit renewal. Okay, my question is, and you said you had a list of these poles and their locators. My question is, the permit for the pole, has that gentleman been, has the owner been here for his renewal? Because if he's come in for a locator renewal, the pole's been up there obviously more than 5 years.
you're right.
So my question is, are we following up with the owners, make sure that they renew their permits?
It's not our job. It's not our job to follow up. It's their job to follow up.
Who's there?
So it seems to me, and that's an interesting question, right?
Yes.
Which is, can we renew a special permit for a user
Yeah.
if the pole itself has not have a current special use permit? There's another way to say it, when you
Exactly.
asked the
And
question you just asked.
And if you're asking for structural validity of this pole, why are you asking?
Well,
why are you
what I was,
asking
so
Verizon?
this is what I was gonna say to Dennis, which is typically, you know, when I saw the structure report, I immediately, I assumed, and thinking it was a motto, I assumed it was
Here we go again.
coincident with the pole, and so now that you're a user, it's a little different. What we've done in the past is allowed the co-locator, upon their renewal, right, to rely on structural reports that were prepared by the
That's what
pole.
we got in the past. We got a
By the
structural
pole owner.
report from the owner.
By the pole owner, we allow them to rely on that, which is essentially what they're doing here, right? He's relying on the report from the pole owner, right, to do that. And a lot of times what we've done
So
is,
it's commingled.
Yeah, but how old is that report?
this was only from July of this year. So the report is relatively fresh, which is interesting. It is an interesting question, and Joe, it's really your question, which is, if the pole does not have a valid special use permit,
right.
can we
Right.
grant the applicant the ability to renew their permit on a pole that doesn't have an up-to-date permit? I mean, that's really, I think the
Or do
big.
they need to get the pole owner to come in?
And I don't,
That's what I was asking.
I don't think the answer to that question can be straightforwardly answered from the code itself, so it'll require a little homework. I don't think you were planning on
There's no
voting
rules,
tonight,
right?
right? So we'll talk and I'll get you the answer, but it is a legal question.
In a way, that seems a little unfair, too. The tenant, it's not his responsibility for the landlord to take care,
We,
it's the landlord's
So we could-
responsibility.
I mean, we could use this as the trigger to issue a
we re-
violation to the pole owner of, you know,
Yeah.
of not updating their permit to get
Right.
him in here.
it might help to read old minutes, because deja vu, we went through this before, and we had an attorney Foley was on our board, and he read the code and brought up the problems, and I remember on that, I don't remember, there was an application on Route 100 up near the highway department, and they got a report. The concern was the condition of the pole, so they got a report from the owner. And he had and it was a current report, and an engineer came out and said, yeah, it was safe, or whatever it was. But what came out of that was we had no system in place at that time for the fact that we required a 5-year renewal. So something was put in place, and somewheres along the line, you came into existence as our planner, and it's an ongoing problem that we didn't fully address, and we were caught being recalcitrant and not following through on our code. We had never asked for anybody to come forward with a 5-year renewal.
Yeah, I think that was
you
that was
remember?
one called Majestec, and I think
Yes.
Chris had suggested the 4-year compromise because of the 5-year due date on the
Yeah,
renewal.
Aren't you concerned that being Representative Verizon, that God forbid this pole falls down?
no,
Okay?
that's not gonna
And you got a permit, and when this pole falls down, you and everybody on that pole and the owner of the pole are gonna get sued. And in that lawsuit, you find out that they don't have a renewed permit for the pole. I mean, that's gonna expose you and everybody else on that pole to an enormous liability.
I don't think that's a concern at this time. As the town engineer said, the report that we have from the tower owner is recent, and there is frequently work going on these towers, replacing antennas, and structural reports are produced all the time. I don't think it's a question of whether the facility is in any way deficient.
But he
I think
doesn't have a
it's-
permit.
But the
I think
validity
it's-
of the permit may create liability in other ways.
Yeah, if he
I
doesn't
think
have a
it-
permit, he could be held in a court case for, well, you tell me.
Yeah, well, the question of whether we are in any way constrained from issuing the permit is different from whether they should be concerned
Right.
and address it amongst themselves, but and I'll get you the answer
I
to the
would like,
first
when
one.
you're looking at that, Joe, to understand the mechanism. So if, yes, we can issue this approval, but we should approach the owner with a notice of violation,
Also a separate question, you're
right? I think they're connected. I think it's this user, and then, okay, based on, what are we doing with the pole owner? Which I think is probably a violation of the special permit, is probably where we're at.
straightforward answer, actually.
Maybe town council can look at this issue and suggest maybe some legislative changes
To make it explicit.
to
Yeah,
make it
to
explicit.
make it
Not only the difference between structural and use, but also the procedures for renewals.
Right. But you gotta remember, sometimes, you're absolutely correct. The structural of the pole should be owned by the pole
That's
owner,
right.
right?
And-
However, sometimes, who knows, this technology changes. Pretty soon, we're gonna have 5G technology.
Yes.
And who the heck knows what those antennas are gonna look like, right? So we might have an applicant coming in like this, that's using your language, a user of the pole that is proposing to change their equipment on that pole, that will have to demonstrate to us that that change of equipment is not going to impact the structural integrity.
Oh, yeah, weight and balance and all that good
Exactly.
stuff. Yeah,
So
no,
there
I
will be instances where there could be a user that could trigger a need for a structural look.
But I don't understand something. When I was on the zoning board, everybody came for an accessory apartment, okay? And when you came before the board to get a renewal every 7 years. And everybody who had an accessory apartment knew that after 7 years, they had to come before the board, or otherwise the building department would give them a violation, okay? Now, if this tower has been up beyond its 5-year permit, if that's what it is, why isn't it part of the permit that this has to be renewed every 5 years, and we don't have to go after you, you have to come after us?
It does say that.
They haven't done it.
They haven't done it.
Okay.
It's in the ordinance and it's in their resolution that they
Okay,
have to
and
go
I-
back every 5 years.
And I'll also say, as members of the board may know, the world of telecommunication towers is different from a regulatory perspective. And so that's why I hesitate to just sort
Yeah.
of spit out an
No,
answer,
it's-
but we'll talk about it and.
They have more rights than we do.
It doesn't seem fair to me to hold up this applicant
No.
because his landlord may or may not have applied for the special permit either.
No,
Yeah, I think that's fair.
And the fact that he has based his
Yeah, let's
application,
make it clear,
Right.
it's us, we're talking about ourselves, I'm
the
sorry.
fact that he has based his application on current structural integrity certifications,
Yeah.
I don't see why we
Right.
can't go forward.
I agree, and after now looking through the file and reading the letter from Tectonic, I'm quite comfortable that it addresses what we needed to address on the
Okay.
structural element and the site
Going
inspection
forward,
element.
let's get it right.
Yeah. Can I ask a quick question? The tower is 149.5 feet tall, is that correct?
139. 139.
Well, it's done in sections, that's why I asked him the
It
question.
says right there, there's a map.
Yeah, but when you do the math, it comes out different.
No, it says 139 feet.
That's all right.
I mean, if that's what it says in the structural, that's what they did the measurements on. Originally, it was, approved and I believe proposed as technically 140-foot monopole, so
Yes.
maybe the way it was built was 139. I think there are tree branches on it, so maybe that's
Maybe that's where the extra height came from?
maybe that's where the extra height
Yeah,
from.
I know.
I'm not sure about that, but
Yeah.
I think 139, 140 is,
Close enough.
I know,
Sorry.
no, that's okay.
Joe or Saret, do you have any more comments or concerns?
I don't.
So my question to Joe is, does he need to see that other report?
Which other, I have both reports.
Did we get the,
There's the structural report here that he just gave us.
oh, you just gave us the one that I requested?
Yep.
yeah, I gave you
Oh,
the
He just
report,
gave us that report,
the Plesson,
signed and sealed.
Oh, okay.
You're just gonna check to make sure
I
that
just
they're
gotta make sure
licensed
Bennett
for
and
New
Pless
York.
is allowed to practice in New York. That's,
What happens if they're not?
Then they're in trouble.
they probably gotta get somebody else,
Okay.
they probably have to get somebody else to sign off on the report. Now, then we could ask the question, okay, this is the tower manufacturer, let's not go, let me see where they are.
But
Yeah.
I might
that
be able to
has-
check it right here
Yeah,
while
you
you
can-
guys
it's-
are talking on this.
It's
Let-
real easy
Let me
to do.
Google it.
Yeah.
They're probably on the second report as well. Just-
So then we need to make a determination whether this should be a type 2.
Right,
Yep.
Yes.
which it is.
I would think yes.
What is my action sheet for? Here it is, okay.
Don't you think?
So you
Should
make a
be,
motion-
I'll make a motion as a type 2 action.
Second,
All in favor?
Aye.
Aye.
How do you feel about waiving the public hearing?
I have no problem.
I have no
No
problem.
problem. All right, then I'll make a motion pursuant to section 170-129, 6G of the town code that will waive the public hearing for this applicant.
And what about the 4 or 5 years? What do you want
I
to do
I
that?
think we were in agreement with 4 years. I think I got that feeling from the board.
Yeah.
All right,
Yeah,
so
let's
we'll
get them
renew
all
this,
back in cycle.
we'll renew this permit then for 4 years.
And it gets $500 back.
Yeah.
Right, so should I prepare for chairman's signature, or you want to see it at the next meeting? The resolution?
Chairman's signature, if Joe's satisfied that
Right.
the technical report is valid for our purposes.
And we have to do these separate, so that our next application then is for the property at 2580 Route 35 on the Santaroni property.
And excuse me, can I just ask
Sure.
that, just to close the circle, that council come back to us and explain that we get an affirmative, even if we're not on the agenda, that we get an affirmative explanation of what happens is if indeed the existing tower on which this collocation is happening does not have a current permit, what's gonna happen? And you're shaking your head, no, Joe, what's up?
No, he's on something else.
Oh, you're on something else, okay.
But we should talk about it. But yes,
But
I
yes.
have that note and you'll have it
Okay.
next time.
Are you looking at whether they're certified for New York?
I will check more deliberately but it does not appear that Bennett and Pless is registered as a professional corporation licensed to practice engineering in the state of New York. You might want to check on that.
I'll check on that.
They probably need to get another business entity that is licensed in the state of New York. Or maybe Tectonic can sign off for them, I don't know. I mean, Tectonic is fine. So this is another one of those interesting questions, right? They're relying on a report that was provided by the tower owner that may be a totally appropriate structural analysis,
Right.
but this company is not licensed to practice in the state of New York.
In
Even though they have a
Chattanooga?
licensed PE in the state, that doesn't mean that the business is allowed to practice in the state. But the applicant has provided us with a letter from an engineer that is licensed to practice in the state of New York. So again, I think we're in a situation where this applicant seems to be doing the right thing, but the reliance on the reports coming out of the tower owner is where the problem lies.
Tower owner is located in Tennessee?
I think the tower owner
No,
deserves a notice.
Yeah. I mean, I see Bentley and Morgan, I just don't think they are.
I mean, because if the state is issuing licenses, right, and regulating the professional practice within the state,
Okay, here we go.
I hate to say it, but it's actually a felony for them to offer or provide engineering services in the state of New York without a license. They can.
well, they've issued the report, but the company that did the analysis, they're not the ones adopting and submitting it. I've created the report, and another party is then taking and adopting it. So it's conceivable that that protects them from the felony, but the issue is, for us, can we accept the document?
Can I rely on this report from an entity that is not licensed to practice in the state if it's endorsed, so to speak, by somebody who is?
And
Another question for you, sir.
exactly, as I said, as a regulated practice, I think that we need to, I don't think this is the last time we're going to encounter such a
Yes.
thing. Let's find out what the answer is.
Yeah.
Yes.
The legal answer, counsel. and-
Just so you know, I have several calls from tower people that are likely to be applicants, so these are questions that are likely to continue coming up, so.
Okay,
Joe?
so even without an application, if we could get some discussion on the agenda, that would be really good.
Yeah, because this is a cottage industry, and often, frankly, the experts are national experts, so we should have an answer.
Thank you.
But you're talking about a structure in the town of Somers. I would want somebody that I know.
Yeah, I'm not saying that makes it okay, I'm making a
Yeah,
point
I-
that it's
I'm-
against
I'm-
all the law.
Right,
I'm
well,
not
what we have to
interested.
worry about is our liability, right?
Yeah.
If
Right.
the
Right.
telephone fell down and somebody says, well, you
Right.
accepted a report from somebody that's not licensed to
Some,
practice in the
some
state.
Chattanooga,
Exactly.
Tennessee doesn't give me any,
Also, just who
Comfort.
actually would issue the notice of violation? Would it come from your office, or is it the building inspector?
I mean, the code enforcement officer.
Oh,
would do
oh,
that.
Code enforcement, okay,
We
okay.
don't have that problem with Santa Rosa because it's,
yeah.
We can make back the 5 million.
I mean, just, again, I check on that, but just as the town engineer said, it is a licensed New York State engineer that is preparing this report. So it's not someone that has no idea of what's happening in New York State.
It's an interesting nuance, because I know that you can be a New York
But
State PE, but if you're working for a firm and you hand out a business card, frankly, right? If I go and hand you a business, if I'm maybe a licensed PE, but I may be working for a firm that is not registered in the state, and I hand you that business card, I'm offering you from that company, engineering services. My understanding, I'm not the lawyer, but my understanding is that in and of itself is a felony.
I'm not clear on that, so I'm not gonna
Yeah,
make an opinion one way or another.
I don't think either one of us should.
Yeah, I
It'll
don't,
be findable, it'll be knowable.
yeah, I don't wanna speculate on anything.
This report would be
regarding
more
that.
valid if it was just issued by the licensed PE and not with any company letterhead on it.
Right.
Because then at least now there is somebody to be held accountable, which would be the individual and not the company.
So then it would be his malpractice insurance, et cetera,
Because as a
which is
sole
why he's a
practitioner, he-
contractor for a larger firm, so he doesn't carry all that.
Right. He would never, I
He's
doubt
not
he's
gonna,
gonna do that.
he's not gonna do that,
Yeah.
because he's
I'm sure we can work this out between now and the next meeting.
I don't think the problem exists with Santaroni property, if I'm not mistaken.
Well, we'll find out. Okay, so why don't we go through the Santaroni one, Michael?
Sure. The comments that we received from that one. We responded to, which was the Technonic Engineering letter. It was requested that it didn't note the other carriers on the property that were on the pole or in the compound. Towards the middle of the page, below the bullet points, a sentence was added similar to the other letter from the other from SCS that just indicates the other carriers that are on the pole and within the compound. Again, we got that list and provided it there. The other thing was, again, the co-location on the tower. I went back to the tower owner. The tower owner has advised that they are working with the potential SC regarding another co-location request, so they have received the request and are working with that. According to the tower owner, there are no other co-location requests at this time. Again, we are not the tower owner, so
I understand.
we're not
Yeah.
privy to those negotiations and tried to get as much information as we could on that, so.
And it looks like Taconic, if I'm pronouncing it correctly, they're the ones that did the inspection, and they are licensed, right?
Tectonic
Yeah.
is fine.
Yeah.
Well,
Yep.
Michael, I'm not sure that something did not happen correctly on my memo. Let me just see something. Oh, December 7. I guess so. Tectonic was also on this one?
Basically, the language on the letter.
Tectonic is this letter. The other one was SCS, Structural Consulting Services, was the letter from the other one.
For,
For 121, Route 100.
2580 is Taconic.
all right, 2580 is Tectonic?
It
Yes.
is Tectonic.
I'm sorry, then the other one somehow got confused here. I apologize for that.
I think your cover letter said New York Ammo Walk 2 on the 2580, and it should have said 3. And maybe that was the point of confusion.
Okay, no, it's structural consulting, no, it's correct, I'm sorry. Structural consulting is the one from the one we were talking about, not Tectonic.
25, and Structural Consulting is the one where I read that sentence off at the time of our visit.
Right.
Existing foundation appeared to
Yeah,
be.
so Tectonic is for this next one.
Correct.
We were confusing that, Joe. So,
And I know structural consulting PC is good because PC is usually the indication you see at the end to demonstrate that they're licensed, that they're registered in New York.
Okay.
But I can check that.
all right, so let's just go through the Santaroni one. Same thing applies to the fee. Statement of users, what, did you give us something new on that?
Well, the Tectonic letter, they added that below the bullet points, they added a similar sentence to what was in the Structural Consulting letter. They just listed off who is at the property on the tower and in the compound, and they noted AT&T, T-Mobile, and Sprint.
3 of them. There's 3 on AT&T.
In addition to Verizon Wireless.
Right.
That was on the original submission, Mike?
No, that's on what I gave in tonight.
The new
There's a
one,
There's a
okay.
revised Tectonic letter that is basically, that's the revision, was
Okay.
to respond to your comment.
And so they're also referencing a Bennett and Pleas report from 7/18/2018?
No, that's on 121.
No,
No, it's on
2580
this.
does the same thing. Tectonic's letter, the end of that paragraph that council is referencing, AT&T, it says, "The field information was subsequently compared with the most recent structural analysis report, job number 18313.06.
Compared with,
Prepared by
right.
Bennett and Pless."
Yeah, I have a problem in a minute. We have this package, Michael. Are you the one that gave us this package?
Yes,
Okay. Is this for both of them?
that's for,
There's a thinner letter.
Ah,
That-
that's
yes.
why I have a problem.
That's, yes.
Thank
But
you.
because it says, the first sentence says that Taconic did the did the inspection on November 13th, the very first sentence.
Right, but it's also referencing, I guess, so Joe, when you read the tectonic letter, there's tectonic's statement, but also within it, they're referencing a report.
Well, no, yeah, the consulting services letter references the report.
The,
The tectonic letter actually didn't reference it.
yeah, it does in,
Yeah,
It just said it was compared with.
Yeah,
But I
we-
mean, I don't see why that's important. What difference does it make? Taconic did the study, who cares?
Oh, it is, yeah,
It says compared with, not
Yeah,
relied
yeah,
on.
Yeah.
well, that's what was clarifying. I actually like the language in the structural consulting services letter better, which says, you know, in our professional opinion, the existing monopole facility meets the requirements of the building code of the New York State and that the existing structural integrity of the facility has been maintained. I like that language much better, right, than.
This looks the same as the one that was
Yeah.
okay before.
Right. So, we'll have to just close the loop on that question, on, does a sign off by appropriately registered and licensed company relying on information from maybe somebody who is not, are we good because it's being basically endorsed by somebody who we know is, and that's a question Joe and I have to work through.
But I don't think they're doing this in the second one. They did their own inspection. They're not
No, no,
relying
no.
on anybody for anything.
no, look, read the
Yeah.
second.
Read Taconic's letter from
no,
December
Read the
7th.
second paragraph.
It references.
it
Yeah.
does.
Read the second paragraph.
Right.
It says, the inspection included a
Limited.
limited visual
Right.
inspection from ground using high-resolution digital cameras of the existing wireless communication installation at the above referenced site. Okay? That means that all they did was look at it through a camera.
Well, I think what that means is somebody went out there, here's what probably happened as somebody who runs an engineering company. They probably sent the staff level person out to take a look, that person looked at it, made their determinations, took a series of photographs, brought it back, reviewed those with the senior structural engineer, and they concluded that it was fine. I mean, that's my suspicion.
Yeah, but
of
the
it.
word, using the word inspection included a limited visual inspection.
Right. Later
Seems to
on-
be opening yourselves up to a lot of problems.
Well, I don't know, I don't want to speak for an engineer, maybe as an engineer you can answer. One of the requirements of the code, I believe, is to have a physical inspection at the property. And my guess is, and I don't want to speak as an engineer because I'm not, is that a limited physical inspection is they didn't dig up the ground, look at the foundation under the ground.
He's
so
protecting
they-
himself just in case there's something bit.
Well, it's just because I'm not an engineer,
What I
but.
liked about this, because believe me, when I read that first sentence, I said limited visual. Okay, when you go into it, they do talk about what was exposed and what they looked at,
Okay.
right? They talk
It says
about the
no-
above-ground foundation.
It says no structural problems were observed with the exposed portions of the pole base, plate, anchor bolts, and foundation.
He can't guarantee something he can't see.
Correct. That's essentially what it's
Okay.
saying. Which I'm okay with as the
Yeah.
co-locator.
Right.
When it comes down, we'll call you.
I have no liability.
And Saret, just for my own edification, why do you care or ask them if there's any other requests for co-location or anything? Who cares? They're not the owner of the pole.
It's not whether I care, it's what was written in the code.
But I don't think this code, this would apply to
Which,
a locator.
Well, I think it does, only because you're renewing something, and as part of that renewal, it gets to this chicken and egg of the pole versus the co-locators. And is the code capable of handling what it is being asked,
Right.
to hold? And there is a
But
limit.
that's the question that should be asked of the owner of the pole,
John,
not a tenant.
I think that's the problem with the code. The
Yeah.
code says it's gotta be done.
I know.
I'm saying it ought to be done for the pole owner,
Right.
not for the users.
Right.
And I think that that's the
And the
right
town
change.
attorney has to look at that and suggest some refinements to the code that the town board can adopt.
I think that one of the things that was going on at the point when we were building poles was that it was very difficult to get information from the applicants and you'd get a request for a poll and then another, and I think that there was a sense among the members of the board at the time, and people who were there, correct me if I'm wrong, that it was very difficult to sort of nail down where was the next request for
Right.
a poll gonna come from. So it may have been, a way of gathering more information when you had someone who was on the site. What do they know? It was an opportunity to get some more information about what's gonna happen in the poll. As I remember, I think that this poll we built so it could go higher. It was designed so that it could be expanded. I remember Sabrina saying, this isn't good because if you build it that way, they will raise it. And we thought it was better plan to do that than to put 2 poles in because it's such a heavily residential area and you can't put the pole in a park. So, because that won't be allowed by the county. So, that's the other thing about this pole, is my recollection is that it was designed so that if we needed further service, that you could go further up with it. Is that sounding familiar to you?
Yeah, it does.
Well, I also remember on this poll, we had a lot of landscaping elements and things like that, not the user,
Right.
but when the tower owner comes in, we have to check up, on those, because there was some obligations about maintaining
I
those.
seem to remember the phrase in perpetuity being
Yes.
used by the representative of the applicant, yes, and that's been going through my mind all night, yes.
Do we know does this pole have a valid special use permit, or is that a question that we have to ask ourselves?
I
and
think
check?
Well,
that's-
let's
we have to do
see
for
the
everything.
dates. Original approval was in 2013, April
So
2013.
they're probably expired.
So they're expired too.
So both of them are in the same
Right.
situation where you have a pole owner that is expired and co-locator doing the right thing, trying to come and get their renewal, and you gotta figure that out. It's probably both
Again.
notices of violations in both instances.
And it looks like-
Notice of 30 days to respond or violation issued? Is that the way that it's done?
Yeah, we'll leave it up to the code enforcement officer, but they're in violation of their permit right now. So my guess is they get a notice of violation.
Also, there was a change of ownership, I think I see it was originally Homeland, now it's somebody else.
Right.
I don't know if that's part of it, what's going on as well.
It seems like the issues are parallel on both of these.
Yeah.
Yes.
Yeah.
Okay, let's go
Except
on.
except it appears that this company is registered in New York State, obviously.
Well,
So that's on.
Both of the
Yeah.
companies adopting the structural
Right.
analysis are registered in New York. It's just a question of, do they therefore take the liability, and therefore can we allow them to rely on a report from somebody that's not registered? And that's a
Yeah,
question that we'll
if
have
they
to.
incorporate by reference, do they have to be
In
licensed?
other words, do they accept the liability of that company, which, so Joe and I will work through that. We'll have an answer
Is
by
that the
next
same
meeting.
issue for this one?
It's the same
Yes.
issue, yeah.
Same issue.
Okay, so,
All right, then, let's, make a motion that we identify this as a type 2 action.
second,
All in favor?
Aye.
Okay to waive the public hearing on this one, too?
Absolutely.
Yes.
Okay, I make a motion, we waive the public hearing pursuant to Town Code Section 170-129-6G. Second?
second.
All in favor?
Resolution.
And the resolution will be based on your answers, obviously, before we proceed further, okay?
And response and advice to the rest of the board, of
Right,
what you determined.
Thank you.
okay? Does he get another $500 on this one, too?
Yeah, I
Yes,
said,
he paid-
he gets
So you
it
get
back.
$1,000 tonight, look at this, huh?
I feel like I'm on a game show.
Yeah.
Yeah, we can make that.
I was thinking
Just a
pizza
quick
for the
question.
planning
So,
board.
The resolution's being prepared, do I need to come back next meeting, or is that something
It's
based
not paid
on,
the audience.
based on the engineer's response to the town planner, that it's?
I think we voted for signature, yeah.
Chairman's
Chairman's
signatures.
signature unless we have some major issue that comes up.
Excellent.
Keep in
Thank you very
touch,
much
but
for your
you don't
time.
have to come back.
Thank you.
Thank you.
Thank you.
Um,
Thank you for being so
Yeah.
understanding.
I forget the date for our next meeting,
Confusing.
13th?
The national company.
Huh? I don't know, I forget.
I'm sorry, what?
I forget the date of our next meeting, I was just gonna announce it.
It's in February
I
sometime.
know it's in February, yeah. It's the second Wednesday of February.
Don't have my card.
Motion to adjourn?
Yes.
Second.
All in favor?
Aye.
Thank you.